So amid this purported cash recovery from the residence of Justice Yashwant Varma, there is indication that the central government is mulling another law on the appointment of judges. Now, according to top government sources, it's still early days yet, but it looks like the centre is not ruling out the option. What could make this easier is that the opposition, remember the Congress too voted for the Njac, is likely to be on board with a new system to appoint judges. Senior Congress leader Jairam Ramesh, in fact, had raised this issue on Friday, while Vice President Jagdeep Dhankhar, who is the presiding officer in the Rajya Sabha, he had referred to the National Judicial Appointments Commission Act, the Njac Act, saying that it was significant. This is an indication of which way the government could likely move in the future when it comes to the appointment of judges. Earlier today, Dhankhar even called for a meeting of the leader of the House, JP Nadu, and the leader of the opposition, Mallikarjun Kharge, in his chambers. Without naming specifically the Njac Act, he hinted at a possible revival of a different system to try and appoint judges. Remember, the Njac Act was passed in 2014, but it was struck down by the Supreme Court the following year, declaring it unconstitutional.
The Parliament, in a much-needed historic step, passed the 99th Constitutional Amendment Bill, paving way for the National Judicial Commission. There was unprecedented support. The Lok Sabha unanimously voted in its favor, with there being no abstention. This House, too, passed it unanimously with one abstention. Rarely in parliamentary democracy there has been such massive support to a constitutional legislation. This was culmination of a basic, fundamental parliamentary process. This historic parliamentary mandate was undone by the Supreme Court.
Now, let's take a look at the main differences between the collegium system, which appoints judges currently, and the Njac, which the Modi government had brought forth, passed in Parliament, but was struck down by the court. Now, the collegium is a system that's based on the three judges case. The Njac is a body created to end the collegium system of appointing judges. The Supreme Court collegium system consists of the Chief Justice of India plus the next four senior-most Supreme Court judges, while the High Court collegium again consists of the Chief Justice plus two of the senior-most judges. The Njac instead envisaged 6 members. The CJI would be the chairperson, then the two senior-most Supreme Court judges, the Union Law Minister, and 2 eminent persons, one nominated by the Chief Justice, Prime Minister, and the Leader of the Opposition, and the other nominated from the SC, ST, OBC minority communities or women. Now, the collegium has no constitutional backing. There is nothing in the Constitution which says that collegium is the way in which judges would be appointed. It's based on a judicial interpretation of Articles 124 and 217, also flows from the basic structure of the Constitution judgment that was envisaged in 1971. Now, the Njac was introduced through a constitutional amendment, Article 124A, the Njac Act of 2014, and was later struck down by a constitutional bench of the Supreme Court. The act, before it was struck down, was passed unanimously by both the Lok Sabha and the Rajya Sabha. The collegium recommends names to the president. The government can object, but ultimately, if the collegium insists on a particular name, then the view of the collegium will prevail. The government's role is limited to getting an inquiry conducted by the Intelligence Bureau if a person is to be elevated as a judge either to the High Court or to the Supreme Court. The Njac, on the other hand, would recommend names to the president. Any 2 members out of the 6 could veto a proposal, ensuring that there has to be consensus. The role of the executive is limited to raising objections or seeking clarifications. It cannot reject if the collegium were to insist. The Njac requires significant involvement via the Union Law Minister and influence in nominating eminent persons as well.